We'll hear argument this morning in Case 23-719, Trump versus Anderson.
The Colorado Supreme Court held that President Donald J. Trump is constitutionally disqualified from serving as president under Section 3 of the 14th Amendment. The Colorado Supreme Court's decision is wrong and should be reversed for numerous independent reasons. The first reason is that President Trump is not covered by Section 3 because the president is not an officer of the United States, as that term is used throughout the Constitution. Officer of the United States refers only to appointed officials, and it does not encompass elected individuals, such as the president or members of Congress. This is clear from the Commissions Clause, the Impeachment Clause, and the Appointments Clause, each of which uses officers of the United States to refer only to appointed and not elected officials. The second reason is that Section 3 cannot be used to exclude a presidential candidate from the ballot, even if that candidate is disqualified from serving as president under Section 3, because Congress can lift that disability after the candidate is elected, but before he takes office. A state cannot exclude any candidate for federal office from the ballot on account of Section 3, and any state that does so is violating the holding of term limits by altering the Constitution's qualifications for federal office. The Colorado Supreme Court's decision is no different from a state residency law that requires members of Congress to inhabit the state prior to Election Day, when the Constitution requires only that members of Congress inhabit the state that they represent when elected. In both situations, a state is accelerating the deadline to meet a constitutionally imposed qualification and is thereby violating the holding of term limits. And in this situation, a ruling from this court that affirms the decision below would not only violate term limits, but take away the votes of potentially tens of millions of Americans.
We are here because for the first time since the War of 1812, our nation's capital came under violent assault. For the first time in history, the attack was incited by a sitting president of the United States to disrupt the peaceful transfer of presidential power. By engaging in insurrection against the Constitution, President Trump disqualified himself from public office. As we heard earlier, President Trump's main argument is that this court should create a special exemption to Section 3 that would apply to him and to him alone. He says Section 3 disqualifies all oath-breaking insurrectionists except a former president who never before held other state or federal office. There is no possible rationale for such an exemption, and the court should reject the claim that the framers made an extraordinary mistake. Section 3 uses deliberately broad language to cover all positions of federal power requiring an oath to the Constitution. My friend relies on a claimed difference between an office under and an officer of the United States, but this case does not come down to mere prepositions. The two phrases are two sides of the same coin, referring to any federal office or to anyone who holds one. President Trump's other arguments for reversal ignore the constitutional role of the states in running presidential elections. Under Article 2 and the 10th Amendment, states have the power to ensure that their citizens' electoral votes are not wasted on a candidate who is constitutionally barred from holding office. States are allowed to safeguard their ballots by excluding those who are underage, foreign-born, running for a third presidential term, or, as here, those who have engaged in insurrection against the Constitution in violation of their oath.
The Colorado Supreme Court concluded that the violent attempts of the petitioner supporters in this case to halt the count on January 6 qualified as an insurrection, as defined by Section 3. And I read your opening brief to accept that those events counted as an insurrection, but then your reply seemed to suggest that they were not. So what is your position as to that?
We never accepted or conceded in our opening brief that this was an insurrection. What we said in our opening brief was President Trump did not engage in any act that can plausibly be characterized as insurrection.
All right, so why would this not be an insurrection? What is your argument that it's not? Your reply brief says that it wasn't because I think you say it did not involve an organized attempt to overthrow the government. So
that's one of many reasons. But for an insurrection, there needs to be an organized, concerted effort to overthrow the government of the United States through violence. And this
so
riot
your point is that a
occurred,
chaotic effort to overthrow the government is not an insurrection?
No, we didn't concede that it's an effort to overthrow the government either, Justice Jackson. Right? None of these criteria were met. This was a riot. It was not an insurrection. The events were shameful, criminal, violent, all of those things, but it did not qualify as insurrection, as that term is used in Section 3.
I would expect that a goodly number of states will say, whoever the Democratic candidate is, you're off the ballot, and others, for the Republican candidate, you're off the ballot, and it'll come down to just a handful of states that are going to decide the presidential election. That's a pretty daunting consequence.
Well, certainly, Your Honor, the fact that there are potential frivolous applications of a constitutional provision isn't a reason.
Well, no, hold on. I mean, you might think they're frivolous, but probably the people who are bringing them may not think they're frivolous. Insurrection is a broad term, and if there's some debate about it, I suppose that will go into the decision, and then eventually what we would be deciding whether it was an insurrection when one president did something as opposed to when somebody else did something else. And what do? Do we wait until near the time of counting the ballots and sort of go through which states are valid and which states aren't?
There's a reason Section 3 has been dormant for 150 years, and it's because we haven't seen anything like January 6th. Since Reconstruction. Insurrection against the Constitution is something extraordinary.
Most boldly, I think that the question that you have to confront is why a single state should decide who gets to be president of the United States. In other words, this question of whether a former president is disqualified for insurrection to be president again is, just say it. It sounds awfully national to me. So whatever means there are to enforce it would suggest that they have to be federal, national means. Why does, if you weren't from Colorado and you were from Wisconsin or you were from Michigan, and it really, what the Michigan Secretary of State did is going to make the difference between, whether candidate A is elected or candidate B is elected. I mean, that seems quite extraordinary, doesn't it?
No, Your Honor, because ultimately it's this court that's going to decide that question of federal constitutional eligibility and settle the issue for the nation. And certainly it's not unusual that questions of national importance come up.
Well, I suppose this court
state.
would be saying something along the lines of that a state has the power to do it. But I guess I was asking you to go a little bit further and saying, why should that be the right rule? Why should a single state have the ability to make this determination, not only for their own citizens, but for the rest of the nation?
Because Article 2 gives them the power to appoint their own electors as they see fit. But if they're going to use a federal constitutional qualification as a ballot access determinant, then it's creating a federal constitutional question that then this court decides, and other courts, other states, if this court affirms the decision below, determining that President Trump is ineligible to be president, other states would still have to determine what effect that would have on their own state's law. And
what about the idea that we should think about democracy, think about the right of the people to elect candidates of their choice, of letting the people decide, because your position has the effect of disenfranchising voters to a significant degree. And should that be something, does that come in when we think about should we read Section 3 this way or read it that way? What about the background principle, if you agree, of democracy?
I'd like to make 3 points on that, Justice Kavanaugh. The first is that constitutional safeguards are for the purpose of safeguarding our democracy, not just for the next election cycle, but for generations to come. And second, Section 3 is designed to protect our democracy in that very way. The framers of Section 3 knew from painful experience that those who had violently broken their oaths to the Constitution couldn't be trusted to hold power again because they could dismantle our constitutional democracy from within. And so they created a democratic safety valve. President Trump can go ask Congress to give him amnesty by a 2/3 vote. But unless he does that, our Constitution protects us from insurrectionists. And third, this case illustrates the danger of refusing to apply Section 3 as written, because the reason we're here is that President Trump tried to disenfranchise 80 million Americans who voted against him, and the Constitution doesn't require that he be given another chance.
To watch this entire oral argument, Go to our free app C-SPAN now or visit cspan.org.